Welcome, everyone, to this edition of On the Legal Side, a production of Private Officer International and Blue Ram Media Group. Happy New Year's 2022. Hope you all have a great year. 2021 is far behind us. 2022 here, wide open. You can write the chapters any way that you'd like. Today, we need to really drill down on a couple of legal issues that are continuing to pop up across the country where private security are involved in situations that they may or may not really understand completely, and thus it puts them into a bad situation, and it puts them in a bad legal position many times. So we want to go over several different areas that may either be confusing to some folks, or maybe they're even intentionally just misapplying the law. But these are areas of the legal aspect of performing our duties that are most often in conflict with what is and what is not lawful for a private security officer to do. So does the law or does it not apply to you often is a question when it really should not be. We say this all of the time in many of our trainings, our radio shows, and other programs, that it's very important that you, as a private security officer, a school officer, a public safety officer, a hospital security staff member, that you understand the law of the land and the law of your state. Don't misapply information that you've heard on social media or maybe even in training classes or other areas to the circumstance at hand and believe that you're covered, because that's where people often get themselves in some serious legal predicaments. Like I said, we're seeing a lot of either confusion or intentional misunderstandings and misapplications of the law. Whatever training you've had, whether that be your regulatory security officer training or other training, maybe you've been law enforcement previously, remember that the law changes frequently, sometimes on a yearly basis. In fact, every year around this time, new laws are enacted. And if you're not up to date on current law, then what you thought was the law last year may not be the law this year. It is true that certain laws do not apply to private security personnel, but you need to know which laws those are. It is not true that because you're a civilian that you can totally disregard many or any of the laws that law enforcement must obey. Yes, we do have certain rights and privileges on private property as the agent of that property if we have either contractually been given the permission or verbally or some other writings where they have extended certain privileges to us as the agent on the property, and we'll get into what some of those might be. In 2015, POI began to catalog the court cases that specifically involved the rule of law, court rulings on legal matters involving both police officers and private security, and how the court has interpreted the language of the law, often differently in different cases. For instance, in a case earlier this year, a private security guard burst through the doors of a hotel room after being denied entry by the hotel guest because the security officer said she smelled marijuana smoke coming from the room. Now, the police did get called by both the security officer and the hotel guest. And according to a police report, the security guard said that after being denied entry into the room, she used a master key to enter the room because she did not want the suspects to dispose of evidence, implying that the doctrine of exigent circumstances applied to her. What is exigent circumstances? Well, first of all, it applies only to sworn peace officers. It allows them to gain entry into a building, a home, a hotel room, or other dwelling when circumstances would cause a reasonable person to believe that entry was necessary to prevent either physical harm to the officers, to other persons, to prevent the destruction of relevant evidence, the escape of a suspect, or some other lawful reason that was developed by law enforcement. Exigent circumstances, which is a doctrine, not a law, has a few exceptions, but it provides the officer access without a warrant, a physical warrant, and supersedes, overrides the Fourth Amendment that requires the parameters of all searches and seizures. The security officer at the hotel, thinking that there was a crime in progress, rather than waiting for law enforcement, rather than waiting for some other application where she could legally enter the room, she decided that the doctrine of exigent circumstances, well, that was going to, if it applies to police, that was going to cover her as well. The fact is that at a hotel where a guest has legally, lawfully rented a room, and again, that's a technical area. If a person has presented a false identification and it's later found out to be a false identification, then you might be able to skirt the law and say, well, they actually fraudulently rented the room under a fake name. That would negate and nullify that legal standing that the guest has that right of privacy, because now a fraud has taken place. However, when we're talking about a private non-sworn security officer, they do not have the legal right to access a hotel room. They do not have the right to access a hotel room that has been legally and properly rented and no rent is due. As long as that room is paid for, the only exceptions that the law allow is in the case of an emergency. Let's say, like with an apartment, you have a water leak from upstairs that's coming through the ceiling into the room below them. Then you can enter it for maintenance purposes. You can enter it for, of course, the smell of smoke or fire coming from that room. There are a few exceptions that the law allows for both the hotel employee or someone who is a law enforcement officer or someone who is maintenance or otherwise to enter a hotel guest room. Very few exceptions. So in this circumstance, technically the security officer was trespassing. She had no legal authorization to be in the room, and certainly by using a master key, she circumvented her legal rights and entered that room unlawfully. Now, in this case, no arrest was made. It did not say that the security officer had probable cause or had any legal right, because there was none. Another situation this year, which is even more disturbing, also occurring at a hotel. A guest was staying at the hotel for several days. The hotel received a call from the mother of the guest, stating that she had not heard from her daughter in several days. And she wondered if security or someone from the hotel staff could go knock on the door and see if she would answer and just kind of check on her and make sure that she's all right. Well, they did that. On the third day, the mother called again and said, "I still have not heard from my daughter. This is highly unusual. Please go in and make sure that she's all right." The hotel took it upon themselves to assign their security officer to take the pass key, the master key, and go and make entry into the hotel room. This is a violation of the law. It is a violation of the hotel guest's right. The proper thing to do, if they suspected that there was any type of injury or other circumstances, a medical issue, the proper procedure would have been for them to contact police and the fire department to decide whether or not this was maybe a situation that would allow them to gain entry into the hotel. Oftentimes, the fire department is called along with the police when a person has not been heard of, especially an elderly person, and we sometimes do make entry into the home after seeing certain evidence that the person may be there, such as their vehicle is in the driveway. They haven't picked up their mail in several days. Their mailbox is full. They're elderly and normally call their children or another party daily, and they haven't done that in 3 or 4 days. Now that develops kind of like a probable cause, that develops exigent circumstance to allow police to authorize the fire department to enter for a well-being check. In the case where security did enter the hotel room, there was a disturbing fact, a disturbing situation, and when we come back from this break, we'll pick it up and let you know what happened. You're listening to the voice of the Frontline Protector right here on the Private Officer Radio Network. Now don't go away, because we are coming right back when we've got a whole lot more right here on the Private Officer Beat Radio.
Life is precious. Ask any of these people. They've been given a second chance at life through organ and tissue donation. But there are more than 84,000 Americans waiting for life-saving transplants. 17 people die every day waiting. I didn't know this until I lost my best friend, Lyric. She gave the gift of life to 5 people. That's why I've become an organ donor, too. One decision saves so many lives. Donate life.
Body Armor USA, we've got what it takes to protect you. Whether you're looking for stab-resistant vests, protective clothing, gloves, body armor, best quality, Contact Body Armor USA on the web today. We've got what it takes to protect you. So we have a security officer who has entered a motel room after there was some concern by a parent to whether or not there was an issue, whether that be medical or otherwise, with the daughter who hadn't been heard from for about 3 days. The security officer on the command or advice or direction of a hotel employee goes up to the room, uses a pass key to enter, and sure enough, there on the floor lies the woman, and in a chair next to a table is a man. Both are lifeless. Both are not moving. Both are not speaking, and both appear to be dead. He checks to see if they're breathing. He calls 911. Police, fire, EMS arrive, and sure enough, both are deceased. It was later determined that it was a drug overdose in both cases. Does this make it okay that the security officer entered the hotel room on their own? On his own volition, he just said, oh, yeah, I can do that. Is this okay? Remember that when we do things, even if we're doing them for the right reason, but we're disobeying the law or going beyond our authority, that still doesn't make it right. In this circumstance, his actions ended up not being able to save a person, but he may have been able to under a different circumstance. But it ended up where he was able to discover these deceased persons and notify the proper authorities. From that standpoint, sure, it looks like he did the right thing. But legally, did he do the right thing? And the answer still is no. The room was still paid for. It was not overdue. They were legally registered in the room. Therefore, again, the proper process or procedure would have been to contact law enforcement and let them make that decision. If the room rent had been due or overdue, that would have gave legal justification to enter the room at that point. Another situation that occurred this year, and there's been several eviction situations, but another circumstance that happened this year was that a security officer entered in an apartment. The person was late 5 days on their rent. The apartment manager asked that the security officer patrolling the property go check. Hey, I want to see if they moved out. I want to see if they vacated. And sure enough, the security officer went to that apartment, used a maintenance master key to see if the apartment had been vacated. It had not. It was an occupied apartment. The resident and their small children were scared by the entry of an armed, uniformed person who looked like a police officer. Was this a lawful entry? Security officers really need to understand both the criminal side of the law as well as the civil side of the law. Under the civil aspect of the law in all states, at an apartment, the lease agreement spells out clearly when management or their agent, usually a maintenance employee, can enter a person's apartment. You cannot, as a leasing company, a property manager, or the agent, you cannot enter an apartment to do what's called a cursory inspection. Inspections must be scheduled prior date and time with the tenant, and they must agree to that date and time. A property employee or their agent, such as security or a third-party vendor who's coming in to paint an apartment or do other repair, cannot enter an apartment unless they have a scheduled appointment. The only exception that the law allows when we're talking about apartments, condos, homes that are rented, any rented dwelling, is in cases of an emergency, what the law calls a qualified emergency, such as a water leak that is pouring through the ceiling, as the example that I gave during the hotel situation, is pouring into another apartment downstairs. Now we have a qualified, true emergency, and we need to get into the apartment to take action to prevent further damage. If the tenant is not available, if there's no one at home, then the property employee, their agent, would be able to access that apartment for that emergency. A smell of smoke or a visible fire, that also would be a qualified emergency. If they smelled something really bad coming from the apartment and they assume, believe, or otherwise think that it may be a dead body, that would not be a qualified emergency. That would be something they would have to call law enforcement for, and they would have to determine whether or not this would be an exigent circumstance for them, and they would then enter the apartment. They may call the fire department to help them to make entry. Maintenance repairs must be scheduled in advance. It has to be a certain day during a certain time frame. Maintenance cannot be done at any time, day or night, without the notice to the tenant. Any other entry into a tenant's apartment would be illegal, whether that be by the property manager or the security agent. You do not have carte blanche. So the law does apply to you in this area. Even though you're a civilian, you're an agent of the property. You have no more authority than what the property manager would have. And their authority to enter an apartment that is under lease is very, very limited. Oh, well, they owe rent. They haven't paid their rent in a month. We're going to go in. No, you're not. There are certain steps that must be taken. This is not a gray area as many assume that it is. There are certain legal steps that must be taken to evict a person, and that includes from short-term, long-term hotels. If it's a nightly hotel where a guest pays for a night at a time and they don't pay for the room, then you can lock them out upon non-payment. For long-stay hotels such as Woodbridge, Extended Stay America, budget hotels, Homewood Suites, in-town suites, or other local hotels that rent both nightly and monthly or long-term, different laws are applied. In many states, after a guest has stayed a certain amount of time, such as 30, 60, or 90 days or more, they have to be evicted through the court process just as though they were renting an apartment. For security officers to enter any apartment or hotel room that falls under the eviction law, that would be an illegal trespass. And the tenant could use physical force to defend themselves because you're breaking the law. You have no legal right into that room, into that space, even if rent has not been paid. Don't misunderstand. If this is just a nightly hotel and they have not paid their hotel rent for that night, yes, they can be locked out. But if this is a long stay hotel, like I said, a maintenance worker could enter for an emergency or for maintenance upon notification, but you as a security officer would legally not be allowed to do so. Understanding which laws apply to you is extremely important. We're going to pick this up when we come back from this break, but many security officers are getting involved in areas which are very dangerous to them, illegal, and could put them on the wrong side of the law. I'll tell you about an eviction that occurred this year with AR-15s and uniform armed security. We're coming right back. You're listening to On the Legal Side.
Driving a car is basically like driving a weapon.
My friend died because someone made a bad driving decision.
My uncle died because someone didn't think before they got behind the wheel.
You let down your parents and your loved ones.
You could lose your friends. Parents don't like their kids hanging out with criminals.
Drug driving is just as bad as drunk driving.
The Federal Aviation Administration wants you to fly your drone responsibly. Avoid flying your drone near other aircraft, especially near airports. Fly your drone below 400 feet. Always keep your drone in sight. If you see a safety issue involving drones, contact local law enforcement immediately. Fly smart. Fly safe. Have fun.
We're back here on the legal side, and listen, we're not pointing fingers, and we're not trying to say that private security versus public law enforcement, one is any better than the other. And like I said earlier, sometimes police are not even aware of certain laws, especially those that deal with the civil side of the legal system. We're explaining what is the best methods to do your job safely and legally. And here's a couple of incidents that have popped up in the news over the last year or so. An eviction at an Aurora, Colorado motel caught the eye of law enforcement, and it was, again, one of those situations that was maybe a misunderstanding at first. I'm not sure. But here it was in Aurora, Colorado, a suburb of Denver. It was at a lower income hotel, a pay by the week, by the month, called the Summit View Inn. Here, many tenants lived week to week, paycheck to paycheck. And during the COVID moratorium, where evictions of apartments and homes and so forth were not allowed, the owners of this motel/inn decided they had had enough of non-paying tenants. So they hired a heavily armed private security force to come in and illegally begin to evict those tenants. The purpose, the owners say, was because they were selling the property. The armed security officers, many with AR-15s, went door to door, ordering people out of the units. Most had no other place to go and frantically packed their belongings under threat of these armed security officers. The COVID-19 Eviction Defense Project filed a lawsuit with the nonprofit housing justice program. The Aurora police responded. The armed security officers physically forced some tenants out of their units. Completely illegal, completely an unjustified use of force, a complete fiasco legally. Law enforcement arrested one person, one security officer, and sent the rest of the information to the Arapahoe County District Attorney. Because of this unlawful eviction, several other lawsuits have been filed. And while this seems extreme, this is only one of 3 similar situations that happened this year. Police in Phoenix were called after Phoenix armed security broke through the doors of a long-term stay motel and physically, forcefully evicted the tenants. Police arrested those security officers. And in New Orleans, a security guard and a maintenance worker were arrested after they forcibly evicted residents who had barricaded themselves into an extended stay motel in New Orleans East. This happened at the Studio 6 extended stay off Interstate 10. Police responded. Workers were arrested, including maintenance worker William Andy Mackey, 56, and security guard Terrence Shaw, 23, charged with aggravated burglary and assault. These cases illustrate the overstepping of private security who may or may not understand their legal authority in these situations or understand the law in these situations. But if you enter a property, a long-term motel, an apartment unit, without going through that legal eviction, and especially these were during the moratorium where there could be no eviction. No one from any condo, apartment, long-term or long-stay hotel, or even someone who was a homeowner could be evicted at that time. Courts, for about 18 months, did not accept evictions. So yes, people got to stay rent-free, but that was the law at that time. There are many cases that have happened through the years where police, under the orders of their client, have overstepped their boundary and broken the law. And this puts both the security company and the security officer into a situation of where they could be both criminally charged and, of course, have a lawsuit filed against them. Understanding the rule of law, understanding the law of the land is vitally important. In one case there in New Orleans, they actually used bolt cutters to break into the rooms of some of the tenants. In another situation there in Aurora, where the guards were heavily armed, some carrying AR-15s, they physically threw people out of the rooms after they broke in. This is far beyond the authority of even police. Police would not be able to do that without a search warrant, an arrest warrant, and even when there's an eviction process, the sheriff's departments who normally serve those evictions, they do have the authority at that point, once they have court papers in hand, to use force to enter the property, but they're definitely not going to use physical force to throw people out. They try to talk with them. They try to de-escalate that situation and find solutions for those people being evicted. However, if those people refuse to leave, they can then be charged with trespassing. If they use any physical force against the deputy or the law enforcement officer, obviously they can be charged with assaulting police at that point. As a private security officer, you can have charges against someone for assaulting you. But you first have to be sure that you are in the right, that you are legally following the law, and that you yourself are not breaking it. We're going to take a quick break. When we come back, we have a lot more. We're talking about understanding the law and how the law does apply even on private property and even with private security.
If you're not already receiving breaking news and our bi-weekly newsletter, Officer Down reports, and discount training news in your personal or business email, then go to our website right now at privateofficer.org. privateofficer.org. A Dropbox will come down. Just fill out your info, and you'll be the first, one of the first, for sure, to know about what's happening in the security industry. You'll know when a security officer is killed. You'll also get these great discounts on training and equipment and so much more. privateofficer.org. And if you're not already a member of the Private Officer International Association, sign up while you're there today. Become a lifetime member for just $99, and we'll also include a free Private Officer International patch and lapel pin.
It's on us to stop sexual assault.
To get in the way before it happens.
To get a friend home safe.
And to not blame the victim.
It's on us.
To look out for each other.
To not look the other way.
It's on us to stand up.
To step in.
To take responsibility.
It's on us, all of us,
to stop sexual assault.
Learn how and take the pledge at itsonus.org.
Premier Training Academy, the premier place for all of your private security, firearms, first aid, CPR, personal protection, and so much more training. Conveniently located in metropolitan Charlotte, Mecklenburg County at 5624 Executive Center Drive, Suite 142, right there in Charlotte, North Carolina. Give them a call. Schedule your training today, 704-806-4933. If you need the North Carolina unarmed or armed training, or the SLED South Carolina security training, or you just need a first aid course or something else, give our friend John a call. I'm sure he'll be able to schedule you and assist you with all of your training needs. The law of the land. We talk about this so frequently because without knowing what the law is, how do you know whether or not you're abiding by it? How do you know if you're breaking that law? How do you know if you're overstepping your boundary? And I've got to admit, there are law enforcement officers who do not know many of the criminal or civil laws because they just do not deal with those laws regularly. There are so many laws in this country, civil and criminal and regulatory and statutory and this one and that one. But it is imperative as a private security professional, a public safety officer, or a law enforcement officer that you stay as updated to the law changes and the new laws that come in usually at the first of every year. It's important. It really is important. One of the other areas that we're seeing more and more security officers overstepping their authority is in the search of private vehicles and individuals. So let's start with when you can legally search a vehicle. I have heard and seen private security not asking, not requesting, but demanding that people get out of their vehicle so that they can search their vehicle for contraband or weapons. It is true that private security in this area often has more authority to search a vehicle or an item or a person than would a police officer who would either need to develop probable cause or obtain a search warrant. In the private sector, especially at apartments, HOAs, housing authority complexes, commercial properties, government facilities, and others, it is easy to obtain legal authority to search a vehicle. And as we have done with my security company, especially in earlier years when we had many HUD subsidized properties and many HOAs, simply slapping up a sign that says all vehicles subject to search beyond this point is legal authorization to search a vehicle. And under the law, if they enter the property with that sign posted, they might say, well, I didn't know it, I didn't see it. But under the law, it's called implied consent. It's just like when you go to a shopping mall or an entertainment venue, almost always they're going to have a sign at the front that says you are going to obey the rules of the property. You are going to not use profanity. You are not going to carry a firearm. You are not going to wear a T-shirt that would, or any clothing that would be offensive to others. And this includes nightclubs and country clubs and restaurants. They often post the same thing. If you enter that property, you're agreeing, it's an agreement, it's a contract, you're making a contract that you're going to abide by these rules. So when you have a posted property that says all vehicles subject to search beyond this point, when they enter, yes, you have the authority to search the vehicle. You do not have the authority to use force to make them get out of the vehicle. You do not have the authority, and you are not acting within the law if you use force against them if they fail to comply. There are two things that you can do if they do not want you to search their vehicle on a premises that has been legally posted. Number one, you can ask them to leave. What happens if they're a tenant of the complex? What happens if they're a homeowner of that HOA, that condominium? Now we have a different situation. No, you cannot detain them. I know that there is a sign that says subject to search, but because they are a legal tenant or owner, you have to let them go. And then you write up a report and make sure that it gets to either the HOA board or to the apartment leasing agent or property management. Should you take it upon yourself at this point to detain that person, you are kidnapping them. No, I don't think so. Yes, you are kidnapping them. It would behoove you to understand what your legal authority is, when, where, and how. If they legally live on the property or they own the property, a condominium or a house within the community, you cannot hold them captive. You must let them go and file a report. Now, they assault you. They push you. They punch you. That's a different situation. Here in the U.S., The law of unlawful restraint or kidnapping is applied when you hold someone against their will without the legal authority to do so. But if they, when you tell them that you're going to report them, you're going to file a report, if they assault you, again, you have to look at all of the other components to the assault. Was it just a little bit of a push? Was it just someone who got up in your face? Or was it someone who punched you? Was it someone that just pushed you away as you got too close to them? Don't escalate. Call the police, get them there, and then file a complaint and have the person arrested. What about a non-tenant, somebody who's a visitor, someone who doesn't live there, someone who doesn't own property there? Now you can, A, ask them to leave if they're not going to comply with allowing you to search the vehicle. And if they do not, at that point, they're trespassing, and you can tell them, look, at this point, you're being trespassed. You can verbally do it, or you can do it in writing. I love doing it in writing because it documents the fact that they have been warned and they acknowledge it. You are being trespassed, sir. If you don't want to comply, that's fine. You do not have to. You can back out of the property. Do not let them enter. Do not let them enter to turn around. I know sometimes it's hard. You've got traffic backed up. The car is sitting there. There's 3 cars behind him. Well, you might have to allow him to make a U-turn to go out. But if he continues through the property, now you call the police and you have them arrested for criminal trespass because they were warned verbally. Don't get into a big confrontation. Don't try to pull them out of the vehicle. Don't try to, we've seen reports this year where security at the front of the apartment at the gatehouse pulled a firearm on someone who wouldn't get out of the car after he refused to comply with their request for identification. You cannot do that. The person going to go to jail is going to be you. Understanding what the law is so vitally important. It's going to keep you out of trouble. It's going to keep you from being arrested or sued. It's going to keep your company from being sued. Please study the law that affects what you're doing. That's going to do it for this edition of From the Legal Side. And I want you to listen to our radio show tomorrow. We're going to be talking about the officer death report, injury report, assaults, and kind of a wrap-up of 2021. Until then, be safe, be blessed, and we'll see you back here on the radio.